Right, and welcome to the first Club Corner online seminar. After the success of the Achievement Scheme seminars, I thought, why not do one on the club constitutions? It's normally at this time of year I start banging on about it in various emails and the BMFA news to prompt you all to start considering your constitution when you get round to your general meeting. Constitution is vital, so I make no excuses for going on about them all the time, but it is a vital element of in your club. Now, interestingly, I get quite a lot of comments. I do quite a lot of club talks, and when we get to talk about constitutions, these are some of the things I hear at the field or at the meeting. It's all just club politics, or we don't need any of that. We just want to go have fun. We all use our common sense, and oh, we've got unwritten rules for this, that, and the other. There is problems with all four of those statements, and these are my general responses that I tend to come out with. All life is politics. Always has been. It always will be. Get over it. It's the constitution generally that means you can continue to have all that fun that you're after. You can soon lose the fun element without an effective constitution. And when anybody says to me about common sense, with 30-odd thousand members, that's 30-odd thousand varying levels of common sense, all slightly different. Whose are we going to use? So common sense is great until everybody has a different version of it. And a number of times clubs have said to me, oh, we've got an unwritten rule. If it's not written down, it doesn't exist. You haven't got it. So they create more problems than anything else, the unwritten rules. So yeah, there's just some of the things I tend to hear quite regularly at various clubs when I visit. So most model flying clubs are unincorporated associations. I think the actual legal term is the clubs of intransigent members, I think they call them, i.e. the membership is changing of different people year to year. And generally for an unincorporated association, it doesn't have a legal identity that's distinct from that of its members. There are some exceptions to that. Some clubs are incorporated. There's probably about a dozen of the BMFA affiliated clubs that have actually formed limited companies. Now, because of these various things, it's very important that you spend some time and some care drafting your club constitution. Now, for the purposes of this particular presentation tonight, wherever I use the word club, I'm talking about unincorporated associations. There are things that are slightly different when a club's a limited company, but because the majority of clubs are unincorporated, that's basically how I'm working tonight. So the issues in clubs generally fall into two categories, certainly in my experience. Because the club does not have its own legal identity, it can cause issues when the club needs to contract with third parties. And that could be buying land or taking a license, a lease on land, whose name's going to be on that lease and things like that. So, you know, it does lead to clubs requiring trustees, which is something that you need to get right. It can cause great problems if it's not right. So, and then the other issues tend to be issues between members. Now, whether that's committee members and ordinary members, or just ordinary members, or indeed between committee members themselves. So your constitution, certainly a well-drafted one, has to deal with both of those issues. So let me find my mouse. Right, so a bit of an overview. The following elements essential for an effective constitution. Bear in mind, this is not an exhaustive list. You know, each club is different. There may be certain elements that you need specific to your club, but there's certain things that you definitely need. Formation of the club, the rights and duties of membership, and the management of the club, how things are run. and what to do on if you know, the club's going to dissolve. So they're all essential things that are in there. Of those four, the formation of the club is generally a fairly straightforward one. You'll have a clause in there that just defines the name of the club. Very straightforward. And then you've got the objects and purposes of the club, which need to be clear. You know, if you say you're only a helicopter club, it needs to make that point. So basically what you're doing, you know, promoting model aircraft flying, what disciplines you do. So people know. And that's what your constitution is all about at the end of the day. It's letting your members know how things are done and what's what, but it also lets the committee know how things are done and what's what, and then you're all singing from the same hymn sheet. Saves an awful lot of problems. So that's the formation of the club element. Then we come to rights and duties of membership, and this includes admission of members to the club, resignation of membership, processes for suspending and expelling members, and things like payment of subscriptions when they're due, that sort of thing. So in terms of admission of members to the club, your constitution needs to define the criteria to be met by any prospective member. And it could be that you want all members to be recommended by other members and things like that. You can also set your own parameters for membership, and that includes any probation period. I recommend you have a probation period. In terms of how long that should be, you need to consider things. I mean, this is just so the committee and the members of the club get used to the person in some respects, so they can see if he fits in. So 3 months, you know, might be a reasonable one, but bear in mind, if somebody comes along in November and joins your club, you might never see them for 6 months because of the weather, or this year, with various other reasons that we haven't been able to go flying. So 3 months you might think is not long enough. At the end of the day, it's a matter for the club to decide. Okay, so, you know, I know there are clubs out there that set it at 6 months and even 12 months. Nothing at all wrong with that, as long as it's in there. And the reason for that probation period is if you find that the member just doesn't fit in the club, either because they're very disruptive or for whatever reason, it does allow you to not accept a continued membership from them. Okay. The third point there, clubs can refuse membership to new members. All clubs are entirely free to turn down a membership application from anybody, and you don't actually have to give a reason for that. You know, they can apply, you can have a committee meeting or whatever, and you can decide that actually this person is not suitable, and then you can just write back to them and say, I'm sorry, we're not accepting the membership. But that last point is very, very, as you can expect these days, the laws of discrimination do apply. So whatever the reasons are for not accepting somebody, you need to ensure that it's not any of the usualisms. So that's vitally important. So moving on, further rights and duties of membership, resignation of membership of the club. Your constitution should define how that happens. I see it a little bit too often, but what I call dummy spitting, and somebody sort of storming off saying, oh, I'm leaving, I'm never coming back. That doesn't that doesn't class as a resignation, or you can't allow that to class as a resignation, people storming off in the heat of the moment. Any resignation should always be in writing, and then you know it's been considered. And the other important part there is define when a member is deemed to have resigned by the fact he hasn't renewed. Okay, so and you could define that, and certainly I would suggest a minimum of 30 days. Quite often clubs will go for 3 months on that one. And after that point, you can treat any a renewal as it's come from a new member. I'm going to bring Craig in there. Actually, that's an interesting question. Craig, if you want to unmute yourself.
Yep. Just on the point about the equality, Andy, if, as we said, if somebody's face doesn't fit or they just don't fit the club, legally, where do we stand with that?
If it's within the probation period, not an issue. You can say they don't fit, or if you haven't decided whether to accept them or not, that's not a problem as long as it's not because of race, gender, sexuality, you know, the usual things. If it's a case of you just don't think they fit in the club, face doesn't fit's the wrong phrase, but attitude doesn't fit is probably the better one. You've no problem at all. You can just say, I'm sorry, we're not accepting your application.
Okay,
no problem at all. But do be prepared to be able to back that up. So nobody can claim it's any form of discrimination. Okay. So going back to members that don't renew. If they haven't renewed after whatever period you define in your constitution, when they then try and renew, you're perfectly, or it's perfectly acceptable for you to treat them as a brand new member. And then if you wanted, you could decide not to accept them back as a member. What you can't do, and this has caused a few clubs issues over the years, is refuse a renewal to an existing member. So if you get to the end of December and Fred Bloggs comes along with his renewal check and wants to pay, you can't turn him down. You have to accept a renewal. To not accept a renewal is the same as dismissing somebody from the club, and you need to follow this disciplinary procedure to do that. Okay, so that's resignation from the club. Needs to be in writing, or they just simply don't renew within the acceptable period. Suspension of it and expulsion of members. This is generally the area that tends to cause most issues, and it's certainly the most likely cause of a challenge to actions at clubs and a challenge to the Constitution. If your Constitution doesn't have a provision in it to expel a member, it's actually very, very difficult to do so. If you haven't got the process in there and you want to get rid of a member, it's practically impossible. And I can pretty much guarantee that if your club throws somebody out without following an acceptable procedure and that person decides to take action, I pretty much guarantee you'll lose, and you will have to take him back. So it is vitally important. It's the one area of the Constitution where I strongly suggest you copy word to word what we have in our example Constitution, because it is the area that's going to cause the most issues. In terms of suspending members, you can suspend a member while an investigation is carried out, and that is a completely neutral act. That doesn't imply any guilt whatsoever. But you could also suspend a member as a sanction for misconduct, and things like that should be defined in the Constitution. Okay, so if somebody's there's been some misconduct, you decide that you want to suspend him from the club, the maximum length of that should be defined. So either 60 days, something like that. Jim's got a point there. Jim, do you want to unmute yourself? Jim Wright? He's not moving. No, Jim has raised a point in the chat there that clubs subs should be refunded in full if a member's not accepted. Generally, if you've not accepted him, he's unlikely to have paid his club subs. But after that point, if somebody is in his probationary period, you could actually do it on a pro rata basis. If he's been a member for 6 months and then for whatever reason you're not going to allow him to continue to be a member, there'd be nothing to stop you refunding half of it, but you should certainly refund any unused portion of the subs. I'm going to go more on disciplinary matters later, probably a little bit in too much depth, to be honest, but it is the area that creates me most work, to be honest. So if this tonight helps reduce that workload, I'll be quite happy, because it's also the area that frustrates me the most. Right, management of the club. This is should include things like the composition of the management committee, how it's made up, and then you should also have you've got management of the club's affairs, things like finances, things like how things are done. Alteration of the constitution, that's vital, and the power to create. It says bylaws there, but in effectively club rules. You know, they all need to be defined in the constitution, so all your members, all the committee know how to do these things. In terms of composition of the committee, the constitution needs to define the number of committee members. I would suggest it should be a minimum of 5, and then always an odd number. But the size depending on the number of members. You know, if you've got 30, 35 members, 5 I would say was plenty. If you have 135 members, you know, perhaps a few more, 7, maybe 9 even. You also need to specify the officers of the committee. Generally, your chairman, secretary, treasurer, and then beyond that, any other particular ones that you need. You might define a safety officer, vice chairman, things like that. You need to clearly define the process for committee elections, so everybody knows if you know how to put themselves forward if they want to volunteer and stand on the committee. I know it doesn't happen very often, but you do need to have that process in place, and the process for removing absent committee members. There's nothing more frustrating getting somebody gets elected to your club committee and then doesn't do anything for 3 or 4 months or doesn't turn up to the meetings. So you need to make sure that's covered in there. I've a question from Keith Miller. Do you want to unmute yourself? Are you there, Keith?
Yeah, I've only got a chairman. Hello, can you not hear me?
Yes, yeah. Yeah.
Oh, okay. So we've only got 2 of us that run our club. Is that a problem?
It's not a problem from any sort of official view.
Right.
There's no issues in terms of affiliation. At the end of the day, it's still entirely up to you how you run your club. And if it's working for you, that's great. I suspect the issues will be if problems arise. And that there is there's merit in having a committee of, say, at least 5 members because it's shared responsibilities.
Yeah.
You know, if everything falls on one person, I've known it create all sorts of problems. And if there's only 2 of you, if you happen to fall out, you know, it can create, you know, lasting problems for the club. So, you know, shared effort, shared responsibility, in my view. Before I carry on, I have another question from Paul Morris. Do you want to unmute yourself, Paul?
Yeah, I think I've unmuted myself.
Yes, I can hear you now. Carry on.
You say that you have to have it's desirable to have an odd number of persons on the committee, but in most cases, the chair, I believe, has a casting vote. So why is that necessary to have an odd number? Why can't you have an even number?
Well, you could have an even number. It's nicer not to have the chairman using his casting vote.
Oh, I see. Yeah, yeah.
It's not an ideal situation, and you still might get that happen anyway if there's 7 on a committee and somebody decides to abstain. You know, you may end up with 3 for and 3 against something. You still may have the chairman using his casting vote.
Okay.
But it is much nicer not to be in that position, and you're more likely not to be in that position if you've got an odd number of committee members.
That's it, yeah, right. I understand. Thank you very much. Thanks.
No problem. Right, I think I mentioned about removing absent committee members. What we have in our sample constitution is a clause that if any committee member misses 3 consecutive committee meetings without good reason, the committee are empowered to remove him and co-opt somebody who's actually going to take on the role. If that's not in the constitution, you just can't. So it's worth being in there. And you need to have a process for filling any vacant positions other than the normal election process. If a position comes vacant after a couple of months, you really need the committee to be able to co-opt a replacement. And again, validity of resignations. People storming out of a committee meeting in a bit of a huff, saying, "Oh, I resign, I'm walking off." I've dealt with a few issues over the years where that's exactly what's happened, and the rest of the committee think, brilliant, okay, we'll accept that as a resignation, and then the chap decides he hasn't resigned a few days later, and it usually ends up with us having a bit of a get-together to try and resolve this. So your constitution really wants to be clear on this and say anybody resigning from the committee must do so in writing, and then it's been a considered decision. It saves a lot of grief. In terms of management of the club's affairs, this should include things like committee members' voting rights and the authority for the committee to negotiate and make decisions on behalf of the club. Always remember that your committee are elected to actually do that. You need to make sure that is clear in the constitution, especially around an expenditure limit. What you don't want is the committee having to come to the members every time they need to go buy a book of stamps or any sort of minor expenditure. So you need to decide on what is an appropriate level of expenditure that the committee can make without having to get approval from the members. You need to define who's, when I say control of club bank accounts, basically who signs the checks, and that sort of thing. And then have define how the committee meetings work. You may decide to define when they happen. Certainly for a larger club, I would suspect that's a reasonable thing to do. For a smaller club, what you don't want to do is put a clause in there that forces them to have a committee meeting, say every month, when there's no benefit in having the meeting. Some clubs will just go with a clause that says the committee will hold meetings as and when required. It's perfectly acceptable. Nothing at all wrong with that. Then you need to define your general meeting procedures in terms of voting. Very important thing for general meetings, know any other business. So we're talking about AGMs and EGMs. It's very important that any business discussed at those is agendaed, so everybody knows what is being discussed. If you accept any other business and something is passed as any other business item, it's very likely to be overturned if it's challenged because you didn't inform the members about it, because of course you didn't know it was going to happen. So if anybody wants to put a proposal forward to a general meeting, whether it's either the AGM or the EGM, they need to inform the secretary in advance, so the secretary can let all the members know that it's up for discussion, and then they can make an informed decision whether they're going to attend or not. And at that bottom point, AGM, EGM calling procedures basically define how far in advance of the meeting they need to be called, and in terms of how far in advance of the meeting any proposals need to be in. So all should be in there. The next one, alteration of the constitution. This is can cause problems on this. Basically, without an express power in the constitution to be able to alter it, it can be difficult to make any alterations to it, because theoretically you need to have a unanimous decision. If just one person doesn't agree with any amendment to the constitution, and you haven't got something in there that defines that it can be a majority decision at a general meeting, you can't make that change. Or if you do, it can easily be challenged. It sort of goes a little bit against what we would expect with things like democracy. You would think if 30 members agree to a change and 2 don't, that you should be able to do it. But if you haven't got that provision in your constitution, it's actually unconstitutional to do so. So within that, you need to define a process to review and amend the Constitution, ideally as part of your annual general meeting. So every year, and as I was sort of saying before we even started, your Constitution is very much a live document. It's never finished. Even our example Constitution, that was amended ever so slightly just yesterday. And these things tend to grow based on experience. So if you have an issue that crops up in your club, and you can learn from that, and you can amend your Constitution accordingly, do so. Things that have recently appeared in the example Constitution is about recording of meetings. We recommend that the secretary can record a meeting purely for the purposes of taking accurate minutes, but really you don't want lots of other people recording the meeting. So define it in your Constitution. Again, we added that, it was actually probably a few years ago now, but based purely on experience of an issue that cropped up from somebody secretly recording a meeting. Yes, do be make sure you've got these things covered. I think we've another couple of questions there. Paul Lewis, you've got a question about internet banking.
Yeah, in your sample Constitution, it states that everything has to be done by check and signed by 2 members.
Mm-hmm.
But nowadays a lot of the paying into the club for the subs and everything like that's all done by internet. And
you just need to define the process in the Constitution.
Right.
I mean, it's probably something I do need to look at updating in the example, but I think if you read the introduction to the example, it does clearly say that's exactly what it is. It's not a recommended Constitution; it's an example.
Yeah.
So
No.
you need to tweak and adjust that to suit your own requirements.
Yeah.
Okay. Right, next slide then. Powers to create bylaws. Generally, your club rules, this is not the Constitution, elements and clauses of the Constitution. These are your club rules, your site rules. They should only ever be changed at a general meeting. However, you do need provision in your Constitution for the committee to introduce new club rules. But they should only ever do that if it's an urgent safety matter. Or it may be something like a legislation change, but you do need a provision in there to be able to do that. But those rule changes should still be ratified by the members at the next annual general meeting. Okay, so you're maintaining the democratic process of selecting new rules then. Okay. And I did mention earlier about dissolution of the club. Constitution should contain the process for making this decision, and it needs to be at a general meeting, and you need to consider what the quorum is going to be for that particular decision. You will have hopefully defined what your quorum is for a normal general meeting. Might be 10% of the members or a fixed number of members before you can actually discuss any business. To dissolve the club, that's a major decision, and you may want to consider making the quorum there a higher percentage of the members. So you might decide it wants to be at least 50% of the members or even 75% of the members. That could lead to an issue that when you call a general meeting for this, you don't then get enough people turning up. The sample Constitution has a second clause in there that states that if the first general meeting to decide on the dissolution isn't quorate, you immediately call a second one where the decision is made by a simple majority. Okay, and all these things are in there. If you decided to dissolve a club and you haven't got all these elements in your Constitution and 2 or 3 people are against it, it's very difficult, and it can create issues. I mean, we hope it's something that you never have to do, obviously, but it does occasionally happen for a number of reasons. within that element of the constitution, you need to have something that determines what's going to happen to your club assets. And that can actually have a wider effects than just what happens if the club dissolves. Yeah, put there grant funding. If your club constitution states that the club assets will be liquidated and divvied up again with all the members, the chances are, whenever you apply for a grant, you're not going to get it. They don't like us. They don't like giving grants to clubs that if they think there's a chance it's all going to be shared out amongst the members and the club's going to close. So you need a clause in there that either defines that any assets will be used to further the aims of the club, even though the club's dissolved. Or alternatively, you could define that it gets given to your club charities. We do have a facility for clubs on dissolution to lodge the funds with the BMFA, and we'll hold them in trust for up to 10 years. And then if the club does reform within that 10 years, the funds are there available for the club to use to start up again. After the 10 years, it will get passed into a development fund, so it will still get used for hopefully the promotion and furthering of model flying. Okay, so that's again, it's an important aspect to a constitution. It's not something we like to think about, but it does need to be there. So I did say we'd come back onto disciplinary matters. This is because it's an area that does create me a huge amount of work, and it's the most frustrating things. Those of you that know me will know I'm fairly laid back and fairly relaxed, and I do struggle to understand how individuals and people within clubs can get into such disputes over very, very little, to be honest. My first response whenever, and this could be a club contacting me or say a club secretary contacting me on behalf of the committee, or it could be an individual club member who considers he has been wronged, and he's they get on the phone and have a complaint. First thing I always say is refer to your club constitution, because that's what it's there for, and it should define the processes. Which is why it's important that it's right. It is the area of a constitution that I said before that is most often challenged. So yes, it's vital, is this. So what we don't want to do is let this, a little storm in a teacup, turn into this. Because if it turns into that, nobody wins, apart from the solicitors. They're usually rubbing their hands with glee. So it's vitally important that you don't do that. So you need to try to prevent those issues developing into a dispute where your disciplinary procedure is required. And it's at that point where it's very useful to remember why we do what we do, which is generally fun and enjoyment. Okay. And I've put it in red there. Will a quiet word in the ear work? For me, that should be your first port of call, and I've underlined quiet because we human beings can be incredibly stubborn, and if somebody starts yelling and ranting at us, telling us we've done something wrong, it tends to put our backs up, doesn't it? And we tend to bridle a bit at that, and you are on a sticky wicket, or you're on a slope to disaster if that's your first approach at dealing with somebody. Have a discreet word in their ear. Say, look, hang on, you're a bit out of line, or you shouldn't be doing that. Certainly, in my experience, more often than not, that works. But if it doesn't, that's where your robust disciplinary procedure comes in. And I did mention earlier that I suggest you drop in word for word what we have in the sample one, because there's only really one acceptable disciplinary procedure that you pretty much can't be challenged. So if you want to suspend or expel members, really you do need to have this procedure, which it's probably a procedure you're familiar with if you've ever dealt with industrial relations or had to sack people in the workplace. It's the same procedure. You are starting off with a verbal warning, This is after the quiet word in the ear. So you've got the verbal warning, which is a bit of a misnomer because it does need to be put in writing that they've had a verbal warning and kept on record. So your authorised committee person will give them a verbal warning, and the secretary just sends them a letter to confirm that that's a verbal warning. Needs to include information of how long that verbal warning stays on file and what the issue was and what they need to do to correct it. If then the member doesn't particularly respond to that, you move on to a written warning. And again, similar sort of thing. It needs to clearly state what they've done wrong and what they need to do to make amends. And if that doesn't work, you then invite the member along to a committee meeting. Again, the invite is in writing, so it's in effect a final written warning, and you need to clearly state that you are considering expulsion from the club. And again, the reasons why and what they should have done to sort it out. If you get to the point where you have made the decision to expel, you do need to put that in writing as well. And again, clearly with the reasons. And it's vitally important that you give them an opportunity to appeal the decision. And that appeal is not to the committee, it should be to the members at a general meeting. Okay. And then if they do take, my experience is they tend not to, but it does happen occasionally. You will have the general meeting, and then basically the members decide either to uphold the committee decision to expel, or otherwise to overturn it and let the chap back in the club. I'm saying chap, or it could be a chapess as well, of course. And if you don't follow that procedure, I can pretty much guarantee that if the person you've kicked out decides to get a solicitor on board, you're pretty much guaranteed to lose that one, and more or less have to take them back in. So follow that procedure. There is one exception to that, and that's for gross misconduct. So if it's gross misconduct, a summary dismissal is perfectly acceptable. You've still got to give them the right to appeal to the members, but you can sort of with immediate effect throw somebody out. And there's a short list there, certainly not an exhaustive list of examples of gross misconduct. So you've got dishonesty, deception, vandalism, violence. Personally, I have zero tolerance for violence and threats of violence, so they should be gone immediately, in my view. But there's other things: misuse of computer and email, sending threatening messages through, things like that, or misuse of club websites and things like that. Misuse of club financial and confidential information. So if you're somebody in the club has got a hold of your membership list, for example, and decides to share that with people that you shouldn't, clearly it's gross misconduct. Things like bullying, harassment, discrimination, you could consider that gross misconduct. All of these things are things where you could decide that it's gross misconduct and just an instant dismissal from the club. But do remember, you do have a requirement to offer them a right of appeal. So problems arise for two main reasons. We're coming to the end, you'll be pleased to know. Oh, hang on, we've got a question from Bill, actually. We'll go there. Bill Scott?
Just if you mess up, you have to take it back in the club. Do you then have to go all the way back to the start of the procedure if something else happens? Not necessarily.
You will find that if you have to take them back, it will be because you haven't done something correctly through the process. So you would certainly have to go back to the point where you missed a step out. So if you just summarily dismiss somebody and that's overturned and you haven't given any warnings, you are in effect going back to the beginning of the process. But if somebody's already had a verbal warning, and then you've dismissed them, the verbal warning could stay on record, assuming it's within the defined time, and then you can just move to the written warning and so on. Okay, and John Minchell, got a question?
Yes, Andy. I'm interested to know why the dismissal process is pretty much the same as if you were dismissing an employee, because a model club doesn't pay salaries, doesn't pay wages. It's not an employee business owner situation. So therefore, why is it so difficult to get rid of somebody who's been unsafe, or I can understand the gross misconduct bit, but if they, I mean, we've had 3 occasions in the last 7 or 8 years where a model club member has been unsafe, and a quiet word hasn't sorted the problem. We've actually sort of made it known, and one of them was an examiner, and he should have been setting an example to everybody else. But the quiet word by 3 committee members didn't do the job, and so it was made known if he would not be invited to rejoin the club. Unfortunately, he didn't. So, after the 3 months or after a year or whatever, we haven't got the problem because he didn't want to rejoin. And that has also happened with the other 2 people as well. They've not bothered rejoining because they could feel which way the wind was blowing. So we haven't had to go through the process, even though we've got the rules written down for the process. But I'm intrigued as to know why a model club should have to act in the same fashion as an employee of a business to get rid of somebody.
Just because it's how society works. It's laws of natural justice, they term it as, and you have to follow it. It's just the way it is. You have certain responsibilities, even as an unincorporated association. As I say, and you do need to follow the laws of natural justice, which requires there to be a selection of warnings before you kick them out. Just the way it is, I'm afraid. You've been quite lucky, I would suggest. I've seen it where people, in fact, I've just been dealing with a case this past few weeks where a renewal simply wasn't accepted because they were claiming he was disruptive. I make no judgment on whether he was or he wasn't. But the upshot was the procedure wasn't followed, and they ended up taking him back. That was a case where the Constitution wasn't up to the job either, which is actually what prompted me to do this, because I thought actually it's probably a good idea. But no, we have to operate in an appropriate way for the society we live in, and that's entirely what it is.
Okay. I think we made our own luck to a certain extent by what we said to the people, and they got the message, so they left, and it didn't think it was a problem. So this is why both Derek Purchard and myself are on this meeting.
Hang on, I'll just mute Paul. So I mean, it will depend on the individuals as to whether that works. I mean, personally, I wouldn't want to be a member of a club that didn't want me to be a member. But and I'm sure there are those clubs out there. But I don't. Everybody's not like that. Some people are incredibly stubborn and will fight or do whatever they can, and it does create an awful lot of ill will and disruption. So, right, there's a few questions piling up there, so we'll go to Carl Burton next. You there, Carl?
Yeah, I think I've got it working. Yeah, I think John covered my point, but we've got an issue of repeated unsafe flying. We've gone through the verbal, I've given a written. The last example was launching a plane with the controller 5 meters away on the ground, and it flew over the pits.
Okay.
So is that gross misconduct, or do we keep going?
Well, you're at the point where, if he's already had his verbal and written warning anyway, but I would suggest, that is verging on gross misconduct, from what you've described. One thing in terms of unsafe flying, which is a different thing in some respects, to deliberate rule breaking. it's a good idea to have a clause in your constitution that anybody, we do have it in the sample constitution, where if somebody's standards fall below the required levels of flying ability and safety, that they rejoin your club training scheme. And that could be a way to deal with that. But obviously, if they don't respond to that, go through your disciplinary procedure. If somebody's already had that verbal and written warning, I think you're at the point where you've got to invite him to your club committee meeting and inform him that you're considering expelling him from the club. So follow that procedure. Hopefully you've got it in your constitution.
Yeah, we've got your copy.
Yeah, oh, that's good.
Very good. Yeah.
I mean, just as a point, if your current constitution that you have doesn't have the disciplinary procedure in that we've got, and you're wanting to expel somebody, follow that procedure anyway, and then you've followed the laws of natural justice, there's more chance that it's not going to be overturned because you've followed an acceptable procedure. But if you haven't got that in your constitutions, you need to be getting it in there fairly quick, having a general meeting and getting your constitutions up to date. Okay?
Okay, thank you.
Yeah, and Chris Bradbury. Are you there, Chris?
Yeah, sorry, I didn't have a question to ask or anything like that. I was just adding to that comment for John there about the disciplinary process. If you don't have a suitable process, you open yourself up to the risk of being countersued or legal action basically for discrimination if you kick someone out without giving a good reason.
Yep.
Or a suitable process in mind. Although it's only a club and we're not employees and everything else, as Andy says, there's still kind of the legal grounds that people can sue you for, unfortunately, in this world.
No, absolutely. We just have to operate in the world that we live in. So you've got to make sure that all your ducks are in a very nice regimented row, and then you don't have any issues. You find
you run the club, get sued or have be taken to court over it.
You tend to find that if a procedure has been followed correctly, that it doesn't go nuclear. They just accept it and go away. It's very rare we get a challenge to a dismissal where the procedure has been followed, and it's not nice that we have to talk about dismissals, but it's a fact of life that some people don't mix well with other people, and it creates issues. So get the ducks in a row, and you should be okay. While you're on, Chris, so you can unmute yourself because you can answer a question. Chris, for those that don't know, is the chairman of the Achievement Scheme Review Committee. And Ian Hunt has a question relates to the achievement scheme. Are you there, Ian? Do you want to unmute yourself? Ask the question.
Yeah, I'm here. I was just learning. Obviously, understanding what you're doing and checking things that are probably missing in our constitution. We talk about unsafe flying and people that may need to go back onto the club training scheme. Can the BMFA actually revoke a certificate or B certificate, etc., for unsafe flying?
Do you want to answer that, Chris, or do you want me to?
You can go on. I was just going to say, first off, the club should really start. I've advised the club to start themselves internally with trying to educate them. There's normally a reason. For Basil's sake, I can think of a couple of members.
Yeah, Chris, no. I'm in complete agreement with you. I just didn't know whether the BMFA could actually remove an A certificate.
There is a procedure to do it. The club applies to the scheme controller. It's not something we like to do, but it happens very, very rarely. There's been, I think, a couple of A certificates and a couple of B certificates removed over the years. It is covered in the Achievement Scheme Handbook if you have a look, but basically it involves applying to the Achievement Scheme Controller and requesting a certificate is removed. It's not a decision that's taken lightly, but yes, there is a facility to do it.
Just to add to that, because one of the things, just coming back to one thing that John was saying about the examiner leading by example, the examiners, you've got to remember they're BMFA Club examiners. So they're appointed by the club. So if you've got an examiner at a club that is bad, just don't ratify them again as an examiner for the following year. Yeah. Same with the club instructors. You've got the facility in the club to control who is your instructor and who is your examiner.
It's actually much easier to deal with an errant examiner than there is somebody with an A or a B certificate from a club point of view, because you just don't ratify them. There's nothing to stop another club ratifying them, and they would still have examiner status then.
And one of the issues of that, if I can just say, Andy, was the fact that this particular examiner was past somebody who wasn't up to an A standard.
Yeah.
And then how do you go and tell that member that, well, in actual fact, we've got our eye on the examiner, and the test that you took, although he passed you, you're not actually up to spec, and you shouldn't have passed in the first place. And that's a difficult situation.
It is a difficult situation. Yeah, it is a difficult situation. But if it's a safety matter, it's one that you just have to take on and deal with it. As I say, having that clause in the Constitution about members falling below the required standard, having to rejoin the training scheme. If you've got that, there's nothing to stop you going up to any member and say, look, we're concerned. Again, it's got to be done really as a quiet word in the ear. That's definitely the process to take to start off with.
Unfortunately, there are too many people who don't respond to a quiet word in the ear.
Yeah. But at that point, if they're not responding, you've no choice but to use your disciplinary process.
Well, yeah, the examiner's left, but the pilot in question has actually got a fair bit better, although he still has more crashes than anybody else put together.
Yeah. So, right, I'll just check my question list. It's getting quite long. Keith, I think you had another question. Yeah. Keith Miller.
Just about the it's this last slide really. So to prevent issues, do it by the book, and after ensuring you have the right book.
Yeah.
Earlier on, you mentioned that the changes to the Constitution have to be done at a general meeting.
Yes.
Can you get into the circular loop of you get to you take it to a general meeting and people turn around and say no, we don't agree with it. And therefore, how do you actually change it?
Well, that's a very good question, actually. And at the end of the day, the clubs are democracies, or hopefully, and we want them to be democratic. It depends what that change is. I've attended quite a number of general meetings where the Constitution has been either a whole new one put in. And as of yet, I think, apart from minor amendments, I don't know if I've ever come across a club that hasn't done it. I think as long as what you're putting forward is reasonable.
Yeah.
Because at the end of the day, most people are reasonable. We tend to highlight on the small number that aren't, but the majority are. So it's almost certainly, if it's a reasonable amendment, going to pass. If it's ridiculous, quite rightly, it should fail. So it is that's just something you have to deal with. There are certain elements, as I say, especially around the disciplinary matters, where you're almost forced to have it in there, because even if you don't, you have to use that process because if it's challenged, it'll be overturned.
Okay.
Yeah. Okay.
Thanks.
Right. Gary Hughes, or Gary's iPad's got a question. Are you there, Gary?
Yeah, sorry, just unmuting. The club in its constitution doesn't have any provision for virtual or online meetings. Mm-hmm. It basically stipulates that all meetings should be held in person.
Right.
In view of the current circumstances, we can't hold meetings or gatherings. So we don't have the provision to amend the constitution. We can't technically get together to discuss it. Mm-hmm. So we're trying as a committee to keep our meetings through email and online.
Yeah.
But we're clearly just going round and round in circles because we're not actually addressing the main issue.
Right. Well, it depends on the actual wording in your constitution. I mean, meeting in person. I think that if you take a reasonable approach, to my mind, we're having a meeting in person tonight. There just happens to be 46 of us.
Yes.
We're in person. I can see the majority of you. For your normal club, how many would you normally get at your club meeting?
15.
Oh yeah, why can't you have a meeting in person anyway? I was at a club EGM on Tuesday evening. There was 15 there, including me. Had it outside. We all sat 2 meters apart. Absolutely no problem in the current situation. Assuming you're in England, it might be different if you're in Wales or Scotland, but certainly in England, it's not a problem. So it is doable.
Okay.
But I don't think it would be an unreasonable thing as long as nobody sort of objected strongly for you to have a meeting via Zoom. But you need agreement really of those participating to do that. But it is something that, in fact, I'm going to make a note of that now. It's perhaps something that we need to consider building into the sample constitution, the facility to hold online meetings if the situation calls for it. And this is what, as I said right at the beginning about constitutions sort of being quite organic and constantly under review, that is an entirely reasonable thing to perhaps amend your constitution with, that you can have virtual meetings.
We've taken the view that we've applied common sense, but as you say, there's 30,000 different versions of it. So,
well, there is indeed, but if the people in the club all agree with that version of common sense, you haven't really got an issue. It's only if somebody was sort of in violent disagreement about it, or if you've got a significant proportion of the membership that couldn't attend a meeting virtually. I mean, for things, shall we say, as important as a general meeting, you've got to make sure you're not disenfranchising any members.
Indeed, yeah.
So, okay.
Thank you.
Right. Chris Anderson had a point to make. You there, Chris?
Yes, I am. Hello.
Hi there, Chris. Okay, we can hear you.
What was I was listening to was John's talk about 3 members that left his club. The trouble being is that becomes another club's problem somewhere else. What we do at our club is we wrote into the constitution that every member would have to have an invitation period of 3 months where they pay £20. If they're accepted by the committee as being full members, then that's fine. And if you're not going to accept somebody, you've not given them a gate key, you've not taken full money, so therefore you have a lot more rights than being a full member.
Yeah, no, probationary periods, I think, well, vital is probably not the word, but they're a very good thing to have. Allows you to deal with these issues quite easily. And you need to make sure that the person's attitude fits. So, yeah, highly recommend a probationary period.
If I can just chip in very quickly, Andy. One thing we did at an old club was we did a rolling probationary period. So it wasn't defined as a month, 3 months, or even 6 months. It was defined as that the member was not deemed a member until approved by the committee. So like Andy said, if you get somebody who joins in November and doesn't come flying for the first time till the next June, they've not got through on a 3-month probationary. They've got through once they're approved by the committee. So the committee, when it's held its meetings, used to sit there at the beginning and go, what list of names have we got? We've got 6 names that haven't been approved yet. Who's met this guy? Anyone happy with him? Yep, he's in. The rest of them, if we haven't met them or we're not happy, they just get rolled over to the next meeting.
Yes, that's what we've done. But the thing to it is that some people don't come down on days when committee members are flying. So we have a checklist that they have to introduce themselves to our 7 committee members and chairman, and it does seem to work quite well.
Yeah.
Andy, one of the things that we did was we mentioned to every new applicant that we had a waiting list. Then we would discuss it amongst the committee as to whether that person was acceptable or not, or who knew him. And if nobody knew him, what we then did as a committee, or at least I did, and I think Derek Perchard did as well, was to actually telephone one of the committee members of the previous club and have a conversation with them. And you know, it may be somebody who's moved from one geographical part of the country to another. And so you just needed a bit of you know, a heads up. Is this guy okay? Is he safe? Can he fly? Blah, blah, blah. Does he need training? Does he need an A test or whatever? And once or twice we'd get somebody saying, don't let him into the club no matter what you do, because he's trouble. Or yes, he's fine. He's just moving from a job down in London to up in the country, and he's fine. Let him in the club. So to be able to speak to another committee member who knows that person from a previous club is actually quite a useful thing to do.
Yeah, I mean, reasonable steps to ensure that people fit in the club is perfectly acceptable. I would caution against going a little bit too far with it. Again, you've got to go back to the fact that we do it all for fun. If you get to the point of interview panels and that sort of thing, I would suggest it's getting a little bit overboard. But just take reasonable precautions to make sure that somebody who comes along fits. Perfectly sensible thing to do. Right, I shall crack on a little bit with the slides. We'll come back to more of the questions there. So yes, I think we've pretty much covered this one. To prevent issues, do it by the book after ensuring you have the right book. Basically, I pinched that one. It's going to be one of my new catchphrases from a chap that I've been working with that they've just redone their constitution after a few issues. And he came back to me and says, so really, we need to do it by the book, don't we? I says, absolutely. So we better write the book then. So that's where that one's coming from. But you will find I will use that one. So moving on, we're nearly done, don't worry. Resources available. We have the example constitution available to download. We also do a constitution review service, and these are all on the new Club Support website, which I'll see if I can open for you. In fact, there it is. You should hopefully see that. That's clubsupport.bmfa.uk. So I'm in the process of revamping the whole web presence. So anything that was on the bmfa.org website relating to Club Support is now on the specific site, but the links will take you to it from bmfa.org. So, and under resources there, you've got the example club constitution. It's all there. I need to add it there as a downloadable PDF as well, but that's the sample constitution and various guidance. We've also got disciplinary advice there. So it's all there for you. And if you want your constitution reviewing, if you click on to request constitution review, there's a little form to fill in, upload your constitution, and then give us a few days. We'll get back to you with any comments and feedback. Okay. So that's the Club Support website. So I'll go back to that. And then sort of, and fine, because you've got to have an and finally bit, haven't you? I did mention at the beginning, club constitution, it's up there as one of the most important assets a club has. If you're going to have a successful club, you need a few, 3, 4 assets, I would say. And I apologise if I do miss anything. You need a decent flying site, obviously. You need a decent, hard-working and sensible committee. You need decent supportive members, and you need a fit-for-purpose comprehensive constitution. In that comprehensive constitution, there will be many clauses, and many of those clauses are just like the insurance. We hope you never need them, but if you do, you better hope you've got them, and it will save you a lot of grief if you have. So that's pretty much everything, apart from the remaining questions. So I'll just go down the list here, see if we've got any, and then we can open up the microphones and we can freestyle for a bit. So I have a question from John Morse. Are you there, John? If you'd like to unmute yourself. Are you there, John? No, he's not responding. So his question was, what if a member is very keen but deemed untrainable? That's a very good question. I mean, somebody may be untrainable but be a perfectly nice person. They may not be causing problems. They're just not picking up model aircraft flying. And in that case, Yes, hear you, John. Yeah, go on.
I eventually found the right button.
Yeah, that's okay. Yeah,
we don't have a problem at the moment, luckily, but in the
Yeah.
past we have, where we've had people come along for very keen to join, but we've had our trainers finding it almost impossible to hand these sticks over to them. So
when you say untrainable, do you mean untrainable because of a poor attitude, or because they're just not able to? They're not picking it up as a skill.
No, they're just not picking it up as a skill. I mean, if they've got a poor attitude, that's a different issue.
Yeah,
You can address that one. But
I mean, if they're not picking it up as a skill, I would say stick at it, and put them on a buddy lead. You know, if they're decent people, why not? You know, I was a member of the Dewsbury Club for many years, and we had a chap that came down. He was mid-70s, and it was very clear that he was never really going to get up to a certificate standard. But he was a lovely chap, and he was very much enjoying it. And I was one of the club instructors, and you know, every Monday I met him down at the field, and we had 3 or 4 hours with him on the buddy lead, and he thoroughly enjoyed it. And why not? So you know, in that case, I would strongly recommend you stick at it. You know, but accept that you may never get to the point of flying unsupervised, and you probably find they accept that as well. But if they're enjoying it, why not carry on?
It's also worth sometimes changing instructor and giving them a fresh approach. Some people learn differently to how people teach. So just moving to another instructor can sometimes help as well.
No, I've experienced that as well. There was one occasion where myself and another instructor were both struggling with the people we had, and we did swap over, and they both came on. So instructor styles can make a difference there as well. Right, on my list then, Chris, the question you had about licensees is probably a more in-depth one, and I'll speak to you through the week on that.
No worries.
Yeah. John, yes, the PowerPoint slides will be available to download, as will the video recording of this. Paul, your question on virtual meetings, Paul Morris.
Yeah, yes, the problem that we have, we're in this catch-22 situation where our constitution states quite specifically that changes to the constitution can only be made at a general meeting at which people attend and vote in person.
Yep.
Now, I take your point about the in-person may be by a virtual meeting, but I don't actually believe that's true in common law, and I just wondered what your view on that was. You know, if you think that in common law that would be regarded as a proper meeting where everyone is voting in person, then hunky-dory, you know, we can proceed. But if as I suspect in law it is not the case, then where do we go?
Common law tends to work, something's acceptable if it passes a test of reasonableness.
Yeah.
Now, if, say, we have the current situation where it's not always possible to certainly meet up indoors, if it's not an unreasonable thing to hold a virtual meeting, as long as you're not disenfranchising an element of the membership.
We would be.
Yeah, so in that case, it's less reasonable. But yeah, you've always got to pass this test of reasonableness, and that's actually what the majority of common law is based on. It's the
yes, the word reasonable is the most used word in law, isn't it?
It is, yeah. It's this fabled man on the Clapham omnibus that if ever you're doing anything relating to regulation or
I met that bloke once. He was a right pillar.
Yeah, he's not quite. Yeah, I mean, but basically, he's supposed to be Mr. Average, Mr. Reasonable, isn't he? Is the man on the Clapham omnibus, and it's a term that's often used in legal matters. And they say, well, what would the man on the Clapham omnibus think? So, and if the action you are taking meets his approval, it passes a test of reasonableness, that you would be fine. But as I say, I think if you're disenfranchising an element of the membership, you're perhaps not meeting that test of reasonableness.
Yeah, I mean, the other part of my problem is that I'm sort of involved in local councils and things, and as an example, there won't be elections of officers, chair, vice chair, all that sort of thing, because we can't hold a meeting, an annual, meeting to do so. And that's actually, well, that's the advice from the Association of Local Councils, which might, of course, change from government.
Yeah.
But it's that, it's a change from government. And so if they're saying that that's not right, are we safe to assume that we're okay doing it as a club?
Well, currently you are, depending on where you meet.
Okay.
When do you normally hold your general meeting?
January, I think. So we should be okay by then.
Well, hopefully things will be better by then.
After the BMFA meeting, very soon after, yeah.
Yeah, it obviously depends on the facility. You are, as an organisation, allowed to hold a gathering, certainly of up to 30 people, as long as you're social distancing at the moment. And you can actually hold a gathering greater than 30 people, as long as it's what they consider to be COVID secure.
Right. So sorry to go on so much. So if we then advertised with the correct notice period a general meeting, if then people said, well, I'm not coming because I'm in special because of my illnesses and so on. Well, that's up to them, isn't it? If they don't want to come.
To a certain extent, yeah, absolutely.
Okay then.
As long as I say, you would need to have taken reasonable steps.
Yes.
If you're likely to have over 30 people there,
yeah.
I know we can all hope.
Yes.
The event has to be run under COVID secure guidelines, and one of those aspects is that you have to do a COVID-19 risk assessment.
Righto.
And then if there's going to be over 30. So again, it comes down to what's reasonable. Unfortunately, January is probably not going to be suitable for an outdoor meeting, which the general meeting I attended on Tuesday was. We held that outside. It was a nice evening, as it happens. Right. Let's have a look.
Thank you for that. Thanks.
No problem at all. We have Chris Anderson has a question.
Yes. What happens with regard to disabled people? In our constitution, we haven't got much about disabled people. Should we have that in?
Not particularly. It's not a constitutional matter. It isn't. Is that you have to deal with them according to it's the Equalities Act on that. So it's not a constitutional matter. In terms of what you need to do as a club, we're going back to that wonderful word of reasonableness again. Much depends on the size of your club, how many members you've got, but you need to take any reasonable steps to make the facilities you've got available to everybody. So say if somebody's in a wheelchair, you need to take reasonable steps. Now that doesn't mean you have to get a tarmac strip put in and tarmac hard sanding and things like that, because that is clearly unreasonable. However, you need to be a little bit careful around facilities. If you've got a clubhouse, for example, it needs to be accessible to people, and toilets, if you have toilets, they need to be accessible. But it's not reasonable for somebody to come to you and say, I need, say, hard standing, based on the fact that most clubs are operating in a field in the middle of nowhere. and it's either not feasible from an expenditure point of view, it might not be something that you could get planning approval for, your landlord might not accept it. So there's it becomes unreasonable to take those steps. It's unfortunate because obviously we want everybody to be involved. Anybody who wants to be, we want to get them involved. You may need to take various mitigation steps. For example, the gate. It might be, if you've got a decent secure gate, it might be difficult for some disabled people to manage the gate, but it wouldn't be reasonable for them to expect you to get rid of your security measures to allow access. But what would be reasonable is to arrange some assistance so they can get through the gate. So again, it comes down to what's reasonable.
Right. Yeah, I understand that.
Yeah.
Just make one more point. When you were talking about virtual meetings, we're holding virtual meetings at our club.
Yeah.
And we're also using WhatsApp for the committee to put ideas to each other. So it's going on every day, so to speak. In the Constitution, it does say that we have to have a minimum for an EGM or an AGM, 50% of the members plus one.
Yeah.
That's worked very well in the past when we have had to have an EGM.
Yeah, I suspect it's the pie and peas you put on.
Well, yeah, but did you have two portions? We were one short.
I might have had two pies, but only one portion of peas. Yeah. I mean, it's an entirely reasonable thing to do. Define that, to be quorate, you need 50% plus one. My experience, some clubs are never going to get that, and it would therefore be a bit of a blocker on actually doing any business at an annual general meeting. So you need to set a reasonable level to be quorate at a general meeting. It would be a mistake to set it at a level so high that you're never going to get it.
We've got 60 members and we've never had less than 40 at an AGM.
Yeah. So
we're pretty well supported.
Mm-hmm. Yeah. So, right. Let's see. Have a look at the questions there. Bill has a question.
Not so much a question, Andy, as it's more a statement. If people are saying that their constitution says in person, is that not more to discourage people from sending in a note saying I want to vote this way, or an email to say the same? They want to actually know that that person is the person placing the vote. So a Zoom meeting would still allow you to see that person raising their hand or putting their vote in.
It's potentially something that's actually quite a grey area. I would suspect that, if it doesn't expressly preclude having a virtual meeting, I think you're reasonable to hold them as long as you're not disenfranchising members. It does need to be something that everybody can attend. Otherwise, you can't be constitutional if members can choose not to attend, but if they physically can't attend, that would then become a problem.
Yeah, going back to that and disenfranchising people, I hear a lot of people saying that they wouldn't necessarily get as many members as they think. With so many of the silver-haired variety these days using WhatsApp, Skype, etc., to talk to grandkids in faraway countries, I think that the numbers that would actually be disenfranchised would be fairly low.
It potentially is, but even if that is one person, is that acceptable for a general meeting? If you were having an annual general meeting and you say you've got 100 members of your club, and you turned around to one of them and said you can't attend, which is effectively what you're doing, you are, I would suggest that's bordering on unconstitutional.
How would you stand, Andy, if you look back at the previous year's AGMs and that person hadn't attended any?
That's their choice,
Good. Isn't
it, rather than forced on them. So I think you need to be a little bit careful there. I mean, it would be something that you could put to the members. I would suggest a reasonable course of action was ask the members. Obviously we say, if you're saying we can't meet in person at our usual venue, are people happy to have a virtual meeting? And if they come back and say yes, I don't think it would be unreasonable to continue on that.
Yep.
So,
okay.
Yep. Okay. John Beck's got his hand up.
Hey.
There you go.
Yeah, can you hear me?
Yeah, I can hear you. Yeah.
Yeah, I'm a member of a very laid-back club. There's about 50 members, and we have about 7 committee members. Our constitution consists of 3 pages.
Yeah.
And the secretary, his opinion is that if it ain't broke, it doesn't need fixing. We've never had any problems as such. I would imagine.
I would suggest you don't know whether it's broken until it's been tested. And what you don't want to do is have it tested and find it is broken. Because then you've got problems to deal with. So if you want me to review it, more than happy to.